Thank you very much, colleagues. And I'd like to start by acknowledging the Australian Law Reform Institute. Commission. Thank you, Justice, for inviting us here today. Let me just quickly welcome our colleagues, or give them a thing. My name's John Williams, you heard. I'm the founding director of the South Australian Law Reform Institute and the provost at the University of Adelaide, and I'm a public lawyer by trade, and I'm doing a sideline business these days in university mergers, Commonwealth and state legislation. Taylor Portelli is working as MKF lawyers, working predominantly in childhood abuse law. Comes to us and has worked with us from the Speaker of the South Australian Parliament. She's held positions in victim support services in South Australia. Taylor has worked on a number of our reform projects, in particular adult safeguarding. She did a great work on the evaluation and the role of suppression orders in South Australia. Pleased to be here in Victoria, which apparently is the capital of suppression orders, according to the newspapers. And lastly, we just completed a reform on the Real Property Act and is helping us on review of the Bail Act. David Plater is the Deputy Associate Professor at the University. David has been working and teaching our law reform class for many years now, has worked on all the major reforms, a history of being a senior Crown prosecutor in London, and worked for the DPP in South Australia. Jeremy Prichard, as we heard, is the Director of the Tasmania Law Reform Institute. Jeremy has long research in the area of child protection, worked in Queensland Cabinet Office and other places, Queensland Crime and Misconduct Commission, well versed in this area. Brooke Washusen is a PhD candidate. She's looking at concepts of family and succession law. Brooke has been a major researcher in our areas on communication partners, supported decision making, the Real Property Act. Brooke has done a lot of the work in terms of that new consultation we do with members of the public, members of the Parliament, and is instrumental in trying to find new ways to get to people. And lastly, Rebecca Bradfield is the Principal Research Fellow at the Tasmania Law Reform Institute, expertise in criminal law and sentencing, long career both with the TLRI and the Sentencing Advisory Council, great work in law of self-defence, insanity and driving offences. Also practices in Tasmania and the Falkland Islands, so something we have. Look, colleagues, thank you very much for seeing us today. We're trying to look at the relationship between law reform agencies and higher education, and particularly through our two bodies and how we use students to move these things. I'm also aware that I stand between you, a break and a libation, so we will get there. I'm moving the wrong way. This is the right way. Let me just introduce, we've got a multiple hand one here. SALRI, South Australian Law Reform Institute, started in 2010. I am very conscious we stand on the shoulders of giants. The Law Reform Committee that ran from 1969 to 1987 had Howard Zelling, many other people which we've already heard about, Alex Castles, Andrew Lidgerwood, James Crawford. South Australia and law reform was something that was synonymous, as you may appreciate. Until the 1990s, South Australia made cars, premium wine and law reform. There was a period after that we got down to premium wine. Now we've tried to move back. So it's 50 years. I was in the Legislative Council 3 days ago. 50-year anniversary of decriminalisation of homosexuality in South Australia, which was in Australia. And it was one of those moments where we had a reading of this Hansard. You don't normally have readings of Hansard about what happened, and including there was Peter Duncan, who was the private members bill who actually made it happen, which of course on the 10th of May 1972, Dr. Duncan, no relation, was murdered in South Australia. A law academic from our law school, and I should have to say that Michael Kirby has been a great supporter and come to South Australia many times to assist us in that, celebrating that. SALRI, this may not be a golden age of law reform, but I'd like to think SALRI is a rare earth, one of those things that may hold some of the future, especially in a small jurisdiction which has many challenges. We have a relationship between the university. Independence for us is academic freedom in many ways, the ability to say what we need. I can't be sacked, certainly by the government of the day. Moving a little bit further, if I could, what do? We do what most people do. We receive our references, we can self-initiate it. We're fortunate in being at a university. A ready supply of experts is not hard to find. We have the ability to call on in the health sciences, in the physical sciences, and in a small jurisdiction like South Australia, we have proximity. We can get to ministers, parliaments, agencies, judiciary, community groups, a point no doubt David will make when he speaks. Also in a small jurisdiction, we're asked to do a lot of after-sale service of our reports, where we have to, without getting into advocacy, we are all often asked to engage with agencies, parliamentarians about how the process works and how we came to our conclusion. Again, one of the benefits of small jurisdictions. David.
Thanks, John. Sorry, anyway, following on from John, looking at the key contributors for our work at SALRI. Well, it's a combination. We're hearing from Brooke and Taylor, two of our outstanding former students from the law reform class. And I think SALRI is unusual, maybe even unique, in that a university-based law reform body. We follow the model from our colleagues in Tasmania, who we work very well with, and in the model from Alberta. So we have a formal linked law reform class that plays a valuable role in our work. And indeed, this is following, some of you may have been last year at the Commonwealth Law Reform Conference and heard from one of our other outstanding researchers, Emily Conroy. So the role of the class and the students that that Taylor and Brooke will be speaking about shortly, that also provides us a valuable source. So when we get funding, whether from the state government on a project-by-project basis or from the Law Foundation, John and my usual practice is we will use the law reform class, draw on the law reform class for our researchers. Also, as Brooke and Taylor will explain, the work that the students do in the class, they learn, as Justice Bromberg spoke eloquently, the unique skills in law reform. So the work that the students do in class is also used in our work. It's their assessment. It's an integral part of what our work is. So our research assistants, generally but not always, we take from recent graduates from this class. We also have an expert advisory board. And as John said, and I think Justice Kirby also touched on the role, the goodwill. So we have local judges, we have barristers, solicitors, the Dean of the Law School. And I think a particularly important member of our expert advisory board is Amy Travers, local parliamentary counsel. So we can't actually produce a draft of bill, as we're hearing today, but Amy's expertise as to the drafting implications is really important. We also, in terms of permanent staff, well, myself as Deputy Director, John obviously is the founding director. It would be amiss of me not to mention Louise Scarman, our tireless CEO. We're also ably supported by the former Chief Judge of the District Court, who's also a tireless supporter. And as we've heard today from various of the other commissions, we have various colleagues, various volunteers, could be retired members of the judiciary, suitable academics on a particular project. So as John said, one of the advantages of a university-based law reform body is a ready source of academic expertise. And particularly here, I'll acknowledge the role of Sylvia Vivilios, our colleague, who's been heavily involved in our work in succession law, done outstanding work, and also in terms of adult safeguarding. Also drawing on the role of the community. And I think one of the themes that's really coming already from this conference is the need to involve the community, not in a token way, but as one of our speakers, as Justice Neave said, the voice, genuine voice in the law reform process. That needs to be brought about or achieved by modern, accessible, multifaceted means. Can't be condescending, can't be patronising, as Taylor will touch on. One of the things really is John and I found quite early on that traditional issues papers, as quoted by the eminent Professor Warner in Tasmania, a dear friend of many of us, they don't stand alone. You need to have other means. One means that we've used, this was done by Emily Conroy, one of our former students, an easy read version of our recent report into guardianship and supported decision-making frameworks. So I think as with all the reform bodies, they might be slightly different, but the core values, impartiality, inclusiveness, independence, are shared by all the law reform bodies who are here today. And moving on to the next slide, I promise I will be brief because Brooke and Taylor will be speaking more about the class. So what is the linked law reform class? It's a year-long elective course at the Adelaide Law School, and I think it's surviving. In fact, I'm sure it's surviving the merger that John mentioned very briefly. Now, one of the processes is we can't have a class of 200, 250 students. It wouldn't work. It works in the format of a small in-person class. We have a variety of guest speakers governed firmly by Chatham House rules, and it's an integral part of the course. So the work that's done by the students isn't like unpaid labour. Rather, the work they do, their assignment, their work it's assessed. It's an integral part of the course and also is of considerable use to SALRI. An educational exercise, full credit as an elective, and it teaches, in very briefly, the unique law reform skills and context, problem-solving business. And we find that our law reform graduates, we now number about 200, and I think 2 of them are here today. I think I saw
I can see Eva at the back.
Eva and Olga, I think, is somewhere either here or listening. Very valuable, sought-after career skills. So really the class is distinct. I know that many other universities and other university-based bodies also draw on students in various innovative ways, and Jeremy will be speaking shortly about what's done in Tasmania. John, over to you.
Thank you. No point being an academic if you don't quote yourself. So there's a quote there which really goes to when I set up the Law Reform Institute 12 years ago, I believed if we were a higher education institution, it'd be strange just not to have students involved in law reform. So the idea of having law reform class associated with the activities, I thought was synergy. These are great students. I think we've heard what we have as a chance. Rarely do we get a chance to build a cohort of about 20 students for 12 months. They have an experience which probably don't get to do in large universities these days. That photo there is, we've got the former Attorney General and the Shadow Attorney General who come to our class. We can call in the Crown Law, we can call in all the people you'd expect to give discussion and frame up what it means to be a good law reforming student, which usually starts, these are our very bright students, they've already got what the law is. Yeah. We can then take them to what the law might be as the next stage. Over to you, Brooke. Now you can hear from the recipients.
Yes, thank you. So my name's Brooke. I was in the class in 2020, so the same year as Eva, who's just started a job with the Australian Law Reform Commission. So essentially what the course is, you get a 2-hour class each week, apart from this week, because we're all here and no one was in Adelaide to teach the students. And part of that, you're looking at the theories of law reform, you're looking at the practices. We look at a number of texts, including quite a few by Michael Kirby, so thank you for those. And another unique thing we get, because it is quite a small class and we do operate on Chatham House rules, is we get a range of guest speakers who otherwise wouldn't be willing to come and speak frankly with the students. So we get a number of politicians, both from government and opposition and independents as well, both state and federal level, judges, current and retired, Aboriginal elders we've had come and speak to our class before, a number of barristers and solicitors and people from not-for-profit groups and NGOs who can speak about how the law impacts them, their true thoughts on what some of the laws currently are and what the law potentially should be. And it's just something that the students would not get if they didn't have this small class where the guest speakers knew they could speak frankly without repercussions. Then what the students also do is, part of their assessment is they, in semester 1, do a literature review and a presentation on that literature review. And then in semester 2, they do an essay, typically on the literature review topic, and another presentation on their essay. So when I was in the class in 2020, the Reform Institute was looking at a variety of things, including powers of attorney, communication partners, and witness competence. I thought powers of attorney sounded dry and anyone who would do that would be boring, and I gave a lecture on it yesterday. So I didn't do that. I was able to pick my own topic. So I decided to look at supposed frauders to gender, negating consent to sexual intercourse and the rights of transgender defendants, which was great because it meant I was able to look at a topic that I was quite interested in and something that not a lot of people have done research in. But a number of my co-students looked at those topics that were currently being done. So a number of students from my class were acknowledged in the Powers of Attorney report that was released in the same year that we were finishing up our law degrees. And then quite a few went on to co-author some of those other papers, including Communication Partners, which I was fortunate to be on, even though I didn't look at the topic in the class. So we'll move to the next slide. Yep. So what is the value of the class? Obviously, we have it there for students. They need to do classes to finish their degree. But what we find, especially because we are such a small institute, is that it allows us to have a greater impact and collaboration, because when students do pick to write and research topics that we are currently looking at, we're able to use that work in our reports. And the way that we do that is if we just use a little bit of someone's work, they get acknowledged in our executive summary. But if we take a lot of the students' work, they actually get co-authorship credits. So we make sure that people are being acknowledged for the work that they are doing. And I think another thing that we do, following on what Justice Bromberg spoke about, was that it gives us fresh perspectives. These are people who aren't subject matter experts. They're not people who have been continuously working in law reform. When they're doing their research, they're starting from the ground up. And one example we recently looked at supported decision-making in South Australia. And because that had come off the back of the Powers of Attorney report, we went into that going, okay, we don't need to look at that sort of ground level research. We're just going to look at different models for supported decision-making rather than substitute decision-making. And because we went in with that view, what we missed was the fact that in Victoria and certain provinces in Canada, they actually have guardianship orders that instead of being substituted models are supported decision-making models. And it wasn't until one of the students did their presentation for their literature review that we realised that we'd missed that. So because she had to start from that ground level and build up, we were able to get something that we had missed because we just hadn't thought of it. And I think that's why it is so important to make sure that we are not just having students, but continuously bringing new students into the Reform Agency, because they just bring that new perspective that we just don't have. And it's not because we're doing anything on purpose, we just didn't think about it. So that was great. Her name was Abigail Douglas, and she did an amazing job helping us with that report. It also teaches the students some really good research skills. And those skills are good not just for if you're working in law reform, but if you do go out into practice, because research, for anyone who has practiced law, knows that it is a big part of the job, and you need to be able to do it quickly and do it well. And it also means that we have some great researchers ready to go when we need them. But unfortunately, because it is a class of very high achieving students, they all have jobs. So it's hard to keep them on. But they are all absolutely fabulous. And the Real Property Act is another example. We finished that this year. And a couple of the students from last year's class who looked at that topic, we kept them on, and they were co-authors on that report. So this just sort of continues on from what I was talking about, the benefits to the students. So it's developing their skills, their research skills, their analytic skills, their drafting skills, their communication skills, which are applicable to any profession that they are going to work in. They think about complex issues, and because it is a full-year elective and they're looking at one topic, they're able to dive really deeply into those and think deeply about those as well. It also helps with their professional growth. It helps them think about what they want to do, because they get such a range of guest speakers. They can see all the different things you can potentially do with a law degree, and it helps them build their identity and their confidence, whether that confidence is in networking or in researching, or just being able to think through a problem and find a way to put your thoughts across to a person you're speaking to. And one thing we've spoken about in the law school and in the class this year is students having an impact whilst they're still in the law school. And that is something that we are uniquely able to give the students, because they have the opportunity to do work on something that they know is going to get looked at by government, that is potentially going to lead to legal reform, which I think is something that you just don't get in the other subjects at law school.
Over to you, Brooke.
Or Taylor.
Taylor, sorry.
Stealing it from you. Consultation to us is just absolutely integral to our work. consultation's not successful if it's not done genuinely and meaningfully with the goal of building a reciprocal relationship. So as part of SALRI's standard practices, we travel regionally to meet with Aboriginal communities, to visit regional Australia, to see how laws made in Adelaide CBD are affecting people hours out of Adelaide who don't have the same services and the same access. From a student perspective, students are able to plan the trips, they're able to come along, they have the opportunity to meet with elders, to actually speak to people who are affected by these laws, to get an understanding of how laws are affecting people on a day-to-day basis, to build that kind of connection. Through the years I've been with SALRI, I've personally experienced the kind of meaningful connection and how we're welcomed into regional communities now. Over the last few years, we would initially go to a consultation with an Aboriginal community and we would have a few elders come. And over years, as we've built that trust, as we've built that relationship with them, we're getting them inviting other community members to come along because we are a trusted body now, because we are there to genuinely engage in a discussion. And as has been discussed today, tokenistic consultation doesn't benefit the community and it doesn't benefit a law reform agency either.
I'd also add one of the benefits of Brooke and Taylor, and I'll say here, their skills in modern consultation, the videos. So I used to design our consultation videos. I will let Brooke tell you how bad they were and what happened.
They were shit, so I fired him.
The students now actually make our videos, and they do a far better job than ever I could.
Yes, we currently use a penultimate law and media student, so that's a paid role. He gets paid for the work that he does, but it means that he's able to learn about the law reform process whilst also using the skills that he learns in his media degree. And he does a phenomenal job, and I trust him wholeheartedly. I just give him the feedback, and he's great. And again, you wouldn't be able to pay a professional videographer to do that, not on our budget, but it's just such a great way to involve the students and, again, show them another way they can use their law degrees.
And I'll mention very briefly international connections. So one of the advantages, I was recently with Matt at the Irish Law Reform Commission, and we were made very welcome there. Justice Clark made a very eloquent address saying that good neighbours are not measured in terms of geography and law reform. And I think not just domestically, but internationally, as we heard from the last interesting panel, the advantage of international connections. We're all facing similar issues, similar challenges, the advantage of learning from each other. And looking at Justice Bromberg, and that's something that Justice Bromberg has often mentioned as well. The picture there shows myself and Emily Conroy at the Irish Law Reform Commission and 3 of our other recent researchers when we were there to meet Matt a couple of years ago at the English Law Reform Commission. Those international and domestic links in law reform are really important. I'll touch very briefly on the recent examples of SALRI's work. The students, these are our recent projects. We also did a huge project on the law of discrimination, and which John might speak about in a minute. The students, or the authors highlighted in blue, are former students from the law reform class or current students from the law reform class.
I will just note, I forgot to highlight Olga Pandos in the Communication Partners Review, but she is also a former student.
And I'd like to, on the subject of Olga was the lead author and researcher on the Mental Health Act review. And again, as the students constantly do, their work was impressive, insightful, impartial, eloquent. It really was. So those students, as Brooke touched on, they could either be co-authors from the work they've done as part of their assessment in the class, or when we get funding from the Law Foundation or the state government, as paid researchers. But John and I treat the students are treated as colleagues. So they are co-authors. They're involved in the writing, in the recommendations, in the consultation. So you'll see the number of students. So as Brooke said, students in some really important areas see their work from class translate into major, really important law reform in South Australia. John, over to you, please.
Thank you very much. Just following on that theme, again, some of the projects we've done, succession, provocation, domestic violence defences, surrogacy, and I should thank our New Zealand colleagues. We had some consultation there when we were doing ours as well. Discrimination and decriminalisation, the abortion one was, as you know, for a very small agency, it's hard to do the big social areas. That's one where I think we got over 3,500 pieces of correspondence on that one, as others would have had. I've still got people writing to me couple still praying for me, I believe. The forfeiture rule, adult safeguarding and other things. The students are very important to this, but, ultimately David and I take responsibility for these reports. We put them together and we make the recommendations to make what they have to do to meet our terms of reference. Should those photographs of us usually handing over something to the relevant minister or the Attorney General and others, we're quite lucky, like many of us. We try and measure what our success rate is, and in some of the areas we're quite successful. It's not uncommon when we give a report, we get a parliamentary acknowledgement about it, and often the parliamentarian or the minister at the time talks about not only our role but also the students' role, which we're very pleased to have. Let me move now to Brooke, just to bring us home with a few student testimonials, and we're nearly there.
Yes, so we have to know I'm not going to read out all of the tiny text on that slide. I'll just do a quick summary for you. I've already spoken a lot about what I've done, but I think some of the particular things that I've gotten out of working for the Law Reform Institute that I wouldn't have gotten anywhere else is having the trust to plan our regional consultations, to run those consultations both in the regional areas and in the city, to go into state. Early this year I was in Melbourne, so I went and spoke to the Juries Commissioner about one of our projects, did that all by myself, helping to modernise our consultation approach, so making sure our videos are things that people actually want to watch and that they're short enough that people will watch the entire thing, which is getting more and more challenging as people's attention spans get shorter and shorter. We've also recently started doing videos at the end of our projects as well, just give a brief summary of what it is that we've found, get people interested, tell them where they can read the further reports. I think a very important thing as well is that when David and John go to present our reports to the relevant minister, they always bring a student along. So I've been able to go to those briefings, brief ministers. I've spoken on panels. Recently, we launched our disability inclusion plan in South Australia. I was able to go along and speak to the panel about what that looks like from a legal perspective and a law and justice perspective. So I think it's just a very unique opportunity that you just don't get in other places, and I think it's great that, with each project, new students are brought on board so that obviously not everyone, but a lot of people are able to get that experience.
Taylor.
Well, you can tell from that slide I'm a talker, and I won't put you through all of that right now. Marcia spoke earlier about the skills of law reformists, and this course is providing students at a university level about these skills. This is the only course that teaches these skills as part of your law degree. You don't get it anywhere else. By the time I graduated, I'd worked on several reports, and by the time I became a practitioner, one of those reports had been passed into legislation. It is a unique and unparalleled experience being able to be part of this course and see the actual tangible benefits of your work. It is phenomenal, and it's something I will always be so appreciative to be able to be part of.
David, we'll just move through another set of testimonials, some students doing some work. We'll keep moving on that one.
Similar point.
Same point. I can make the same point with, again, this was this was an interesting one, the surrogacy one in particular, private members bill. We worked with government support at the time, but we worked with private members for a surrogacy, which I think was a very difficult piece of reform here in South Australia. But again, an opportune time to get involved in a difficult project.
And the student was amazing because she, as part of her working class, that was the Honourable John Dawkins, the gentleman in the middle. He'd been speaking about surrogacy for 20 years in the South Australian Parliament, and Maddie Thompson, the outstanding researcher from the class, had read every word he'd ever said in hands under for 20 years. So she brought again a wealth of expertise when we were able to get funding for that, and she made a very valuable role on that very sensitive reference.
So Taylor, and then we'll have a couple of questions.
Look, from the student perspective, you're getting these incredible connections, you're getting amazing opportunities, you're getting to see the practical benefit, you're getting to meet communities to see how your recommendations could potentially affect them on a day-to-day basis. There's this real capacity for this tangible benefit. from the perspective of SALRI, we're getting perspectives from students, which is not part of our normal consultation. We don't get university-age students coming to consultation normally. We've got this generation of ideas, and also criticism on SALRI is that we've got Brooke's class who gets to critique David's videos. It ensures that we're always moving with the times. It's such an incredible partnership, and it has massively increased SALRI's capacity and output.
And I will just add, we still show the videos to the students and they still criticise them. So we're not perfect, but we appreciate it because they know what younger people are going to watch. And even though I'm still in my 20s, mid-20s, I am ageing away from what the young people are doing. It's important.
It ensures we remain accessible.
Yeah.
So on that ageist note, colleagues, one of the great things about being in the academy is putting time into the academic purpose, and the academic purpose is educating the future. We have nearly 200 alumni now from our course who are well trained, they understand law reform, the challenges of law reform, and we release them into the world. So I'm very pleased to be part of that. With that, that'll end with SALRI. Let's talk to our great colleagues at Tasmania. How do you involve the students in the process?
Thanks, John. I know it's not common to discuss age, but while we're all here and talking about how old we are, we're nearly 25, Jeremy and I. So we were established in 2001, and over those years we've had 3 directors who've all been senior academic staff at the law school. And in that time we've published 60 publications, which wouldn't be possible without the involvement of students. So through our time, either as primary researchers and co-authors or as research assistants under the guidance of a member of academic staff, our publications have been prepared with the assistance of students, taking very much at times a lead role in being the primary or lead author of papers. We don't have at the University of Tasmania a class in the same way, but in different ways we've involved students as well. We've had 3 funded higher degree positions. We've had a PhD that was successfully done and is now Lorana Bartels, who's a professor in Canberra. She completed her PhD on suspended sentences, which was part of our sentencing reference. We had a project on non-consensual male circumcision, and the author of that completed his master's that was based upon the research he'd done with that. And Jeremy and I currently have a PhD student who's looking at, or will look at, parental attitudes to allegations of sexual offending by young people. And that comes out of the project that we're currently working on, which is on justice responses to young people with harmful sexual behaviour and sexual offending. And through the Law Reform Institute, we also have a Vanessa Goodwin Scholarship, which was established in 2019. Vanessa was the Attorney General in Tasmania, but she was also a PhD graduate of the law school. And in recognition of her support and contribution to law reform, we have a funded internship with us. A 4th or 5th year student can apply for that, and that's separate to their regular coursework. The student, under the support of the staff at the Institute, will develop a research proposal, write the paper, and then have the opportunity to present it to the attorney. This year, our Vanessa Goodwin Scholar is looking at fair warning in the law, which ties into and is relevant to what we're looking at in relation to young people and sexual offences. And for the first time this year, we have a student from a undergraduate course who's doing his internship with us. So the law school has a program where students are involved in clinical legal education. They go out to community legal centres and the like. And this year, for the first time, we've got someone working with us, and he is sort of shadowing, coming to meetings, but he's also integrally involved in a current reference that we have, which is looking at the review of the Coroners Act in Tasmania. So he's doing a particular aspect of that project, doing the research, and we will incorporate that into our issues paper.
Thank you. Jeremy.
Over to Jeremy.
Thank you, Beck. Look, very briefly, I'm aware of time. Talking about similarities, I think from our perspective, we feel that the model that we have, being based at a law school, but being independent of the university and independent of government, works really well for us. Even though we're independent of the university, we're very much a part of the academic community within the law school, and sometimes more broadly, we have two colleagues from psychology who are working with us on a particular project. We're very much aware of there's benefits that flow to students from the location of the Law Reform Institute in the law school, but we're very much aware of the benefit that flows to us. I think we've incorporated into our units, of course, law reform issues. I've taught criminal law for 18 years, and I think through fresh minds that you get in the classroom, you do encounter that blue sky thinking that you were talking about previously. So it's very healthy and beneficial for us all together. I think one thing I'd add is that since 2023, we've really tried to make it, through practical means, much more attractive for members of the law school staff to either to lead or be co-authors of law reform projects, and to approach us with ideas. And that's fantastic, because it's great for their CVs and their careers for various reasons. We benefit from their expertise. It's cost effective, and they get, we seek and secure external funding for many of our projects, and so they get the benefit of that. But also, they naturally, it affects the culture of the law school. So in as much as in their units, the idea of and the belief in the benefit of law reform is imbued and comes across. So we've had either working on or completing, we've had law school academics working on corporate law and governance projects, privacy law, constitutional law, environmental law and family law since 2023. In terms of the big difference, we don't have a law reform unit like SALRI's. It is unique. It's a model that we would love to adopt. Another major difference is we don't have David Plater, who I've never seen you in the classroom, John, but we are lucky to have him teach in our law school. He's electric. I've never seen a better teacher. But success has many parents, John. I would like to point out that David did his PhD at our law school. So
I should actually confess, John, myself, Rebecca, Jeremy, all have links to Tasmania, and you too, John, don't we?
We do, and we won't be going into them now. Colleagues, let me conclude where I started by thanking Justice Bomberger for having us here today. We really appreciate it. And I also started by saying that we all stand on the shoulders of giants. Michael Kirby, thank you.